these sessions. I've had a number of requests asking for access to the one the other day. That's going to take me a couple of days to get this in an order where I can put it up with a link. I've been laptop challenged over the past couple of days. So, Tom, before we get to the briefing of the rules, if you could very quickly explain what the deadlines are for people who wish to comment and how they should comment to the proposed committee rules so the HISA board can consider that.
Yeah, thanks, Ed. First of all, welcome everybody. This is the second of these types of regulatory network calls. And we had a good turnout on Friday last week to talk about racetrack safety proposed rules. And now today it looks like there's a lot of interest as well. And we're eager to receive your comments. The proposed rules are posted on the HISA website. And there's a means of registering and commenting. That's one way to do it. You could also send written comments if you wish to myself or Jim Gates or the Usada people on the call. But I think the best way to get all these comments aggregated is on our website. And there will be more rules drafts to complete the anti-doping and medication program proposed rules in the next couple of days. And we're working on posting those now. And Jim can maybe give us more definite information about when those are available, but we anticipate in the next couple of days.
What is the deadline for submitting comments prior to the HISA board consideration? Do you have have you posted a deadline for that? That comments need to be received no later than such and such a time to be considered by the HISA board?
Yeah, the HISA board is going to be meeting on December 2nd. So any comments received before that date would be in the mix to be considered by the board. And certainly any comments received thereafter or submitted to the FTC once the package is submitted to FTC on December 6th would also be comments that are taken into consideration both by HISA and the FTC.
So if I understand the scheduling order from the FTC, comments that are provided to the HISA board become a part of the submission. And is that correct or not?
I think what happens, Ed, in the submission is that the submission is required to respond to any comments that have been received as part of the process prior to the submission. So those may be aggregated. They may be submitted as exhibits with the submission, but more likely than not, they would be aggregated into like comments and responded as part of the narrative.
Okay. So we're here to be briefed and for the HISA representatives as well as the Usada representatives to brief everybody on the proposed rules, which have been forwarded to the HISA board from the Anti-Doping Standing Committee. Who wishes to brief everybody? And I'm sure people have a lot of questions. If you have a question, I'm going to ask that you raise your hand using the reaction tab at the bottom of your screen. If not, start waving to your camera, and I'll try to recognize you if you can't get a reaction tab. But if I see you, because I've got 3 pages of video participants. Who wishes to go? Yes, that's Dr. Muir from USADA. Do you want to start?
Yeah, thanks, Ed. And I won't take too much time. I know Jeff's got a few things that he was just going to talk through from some of the infographics we had done as part of the sharing of the proposed rules. But just to say, obviously, I've spoken to a lot of you on some of the previous calls, and it's great to see some now familiar faces, and hopefully I'll get to see some of you in the flesh at some stage too, now that COVID restrictions are easing. But Yeah, it's really great to get the engagement, and thanks to Ed again for organising this call so that we can have the discussion and get some questions and thoughts from you on the proposed anti-doping and medication control rules. We obviously got some really great feedback during the first round, which allowed us to make some amendments to those rules, and again look forward to your thoughts. I know that Ed and I have spoken, and maybe some things are a bit different, and hopefully Jeff can do a little bit of explaining and background on some of those, but obviously any questions you've got, we'll hope to answer where we can on the rules. One thing you'll also notice, a few of the documents haven't come out yet. There are a few that will be posted on the HISA website in the next week or so, and then also, and I don't know whether any of you have seen any of the media stuff, but things like the whereabouts policy will be something that will be phased in over time. So as far as that document goes, we're not proposing posting the full sort of where we want to get to in relation to that, because that will require some work, some technology development to ensure that it's something that's achievable for people to do. So some of the documents will be coming out shortly. Another one you maybe have picked up from the prohibited list, the guidance on the use of therapeutic medications that are commonly used in training. That's all coming. We're looking at that data with some of the experts, and we'll look to post that so that trainers have got guidance on use of those medications in training. So some of those things will be to come, but just to sort of put a pin on those, as far as we know they're not there yet, but they will be forthcoming in time. So as I say, I'll pass over to Jeff to give you a little bit of background, and then we'll open for questions. But yeah, great to see everyone again, and onwards. Over to you, Jeff.
Thanks, Tessa. And I haven't had the opportunity to meet many of you, but my name is Jeff Cook. I'm the General Counsel of Usada, and wanted to spend a few minutes just kind of going over the rules at a fairly high level. And Ed, I'm not sure if you can let me share my screen, or if you have input.
Yeah, I'm going to just make you the host, so you could share it from then. Then when you're done, when we take questions, I'll take it back.
Sounds good. Thank you.
Okay.
So the screen that's being shared now is a graphic that we created to give a high-level overview of the sanctions. I know this is an area that all of you are very familiar with under the ARCI rules, and something that's going to be a little bit different under the protocol. So I wanted to make everybody aware, just generally speaking, what that means under the new protocol, or the draft protocol, I should say, at this point. So for a positive test, there is going to be strict liability for what's called the responsible person, which is generally speaking the trainer. And the penalty for a positive test for a primary substance, which is generally in the category 1-2 range that you're familiar with, is going to be up to 2 years. That can be doubled if there are aggravating circumstances present, and aggravating circumstances are basically evidence that they were using this multiple prohibited substances, or they were using them in a manner that was clearly tied to impact the horse's performance. So there are enhancements available. And then with second violations that can, within a 10-year period for primary substances, then that can increase to double the sanction. So that would be up to 4 years. And then for a third or more, the top end is up to a lifetime, again, within 10 years. One thing important to note related to the multiple violation multipliers is that the act does not allow us to look at anything that happened before July 1st, 2022. As much as we would like to do that and think that it's reasonable, rational, and all of those things to do that, the act strictly prohibits that. So just wanted you to be aware of that. So for secondary substances, these are more of the therapeutics that are prohibited, would be prohibited on race day. Those are called minor infractions, and those are going to be subject to a lesser range of sanction. And you can see there that it's up to 30 days and a fine. However, if aggravating circumstances are present, or if it's the fourth violation within a 5-year period, then it can be brought over to the major infraction range and have the sanctions that I just described of up to 2 years. And so that can either happen again, it can happen in someone's first violation if there's evidence that they were really using that medication to abuse the horse, impact performance, or if somebody's a recurring offender and has 4 violations within 5 years, then that fourth violation and every violation afterwards would be considered a major infraction. So this is, as I mentioned, this is for a positive test for presence of a prohibited substance, use, possession. This is the sanction regime. Those are the most common types of sanctions. This would apply, as I mentioned, for strict liability for that responsible person, but that doesn't mean that that's the only person that could be charged with respect to a positive test. We're going to look closely at veterinarians, at who was doing the administration, and certainly if owners were involved, then they could be charged as well. It's just not going to be a strict liability offense against those people. There'd have to be evidence that they, for veterinarians, they knew or should have known, excuse me, that their conduct was a violation, for example. So for other violations, and just let me step back. So there are 12 violations under the rules. 3 of them are the ones we just mentioned in terms of presence, use, and possession. There are several other ones that are listed here. And so for these violations, there's a bit of a range of different sanctions that could apply. For evasion, tampering, administration of a primary substance, trafficking, complicity, retaliation, that's treated the same way as a primary substance positive, where you have up to 2 years, and then same with aggravating circumstances and multiple violation multipliers. That all applies. For whereabouts, a little bit of a different sanction there, up to 1 year, and again, the specifics about the whereabouts policy, as Tessa mentioned, have yet aren't really going to be too relevant for July 1st, so I'm not going to spend much time on that now. Then there are a couple other violations that we're treating as minor infractions, so similar to the secondary substance positive test violation, and those would be failure to cooperate and administration of a secondary substance, generally speaking, and then MCRV stands for medication control rule violation. And that's defined specifically in the rules, but it's 2.12 is the article that deals with that one, and that is for this purpose, it's referring to violations where the treatment is beyond the minimum necessary to treat the covered horse, and that's language taken again directly from the Act, in terms of what the Act is trying to prescribe for horse racing. And then the other portion of the medication control rule violation referenced here is if you're not, most likely be a veterinarian, is not handling drugs in accordance with state or federal law. That would be a violation as well. So then all the sanctions I just mentioned, all of these sanctions deal with people, right? So as I mentioned, a responsible person or other covered persons who are doing something that violates the rules. So then there's a separate sanctioning regime for horses that includes automatic disqualification of race day for race day violations. And then the sit-out period, or the sanction for the horse, will be very dependent on the substance for which they tested positive. So there's generally no period of ineligibility or sanction for a horse if it's a therapeutic, for example. But if it's a steroid or something else that has a ongoing effect in the horse, then there will be a sanction for that horse, or a sit-out period for that horse. And those terms, those links of sanctions are outlined in the prohibited list. There's a table that has the substance listed and then has the time. So you can check that out there. And then for whereabouts violations or evasion or refusal, there would be a 12-month sanction for the horse, because of course, we don't know what the horse was using because of that violation. So that's why there's an impact to the horse there. So that's the general overview of the sanctions. I have one more graphic to share related to the results management process that I hope you all can see now. So I think many of you will find this process fairly familiar. So we have collections, and those samples are sent to the laboratory, and the laboratory reports the results. So of course, if it's negative, then notice is going to be sent to a responsible person, owner, and authority. And if it's an adverse analytical finding or a positive test, then notice is also going to go out after we review the abbreviated laboratory documentation. And notice of an adverse analytical finding is also sent to the responsible person, owner, and State Racing Commission, if applicable. And I say if applicable because provided the State Racing Commission agrees to the general confidentiality provisions within the protocol, then there's no issue with providing those results to commissions. And every finding of a violation is going to be public. It's required to be public. And so everybody will know about any violation that has occurred under the rules. At the time of notice, there could be a provisional suspension imposed. Provisional suspensions, I know that's a new term for many of you, but what that basically means is that the person is starting their sanction before a final resolution has been determined. And that's important for a couple reasons. One, it's important to make sure that, for example, the horse is not racing in a race the next week if they're still receiving the benefit of the violation of the prohibited substances that the horse was using. And similar for a trainer who's facing a 2-year sanction for a serious offense, we do not want that trainer to continue to be involved in racing horses while their case is pending and they're facing a serious violation. And so that's why the rules say that the provisional suspensions are only mandatory for primary substance and primary method violations. So they're not mandatory for anything else. There's discretion to impose a provisional, and that discretion is needed because, as I mentioned during the sanctions overview, if there are aggravating circumstances or there's something that's really, really wrong with the situation, we would want to have the discretion to go ahead and impose that provisional suspension. And in other cases, the provisional suspension can be immediately challenged, and that challenge will be heard by a steward or an arbitrator. And that challenge, the provisional suspension is going to be upheld if probable cause is found of a violation. And that's very analogous to how things work in the court system in terms of those initial findings and consequences related thereto. In addition, if there's an upcoming race, the whole process can be expedited and the hearing can happen in a matter of days if that is what the person charged wants to do and it's reasonable under the circumstances, then Usada or the agency would make that happen. And that's allowed for in both the protocol and the arbitration procedures, which will come out, as Tessa mentioned, in a few days, likely on Monday. So that then brings us to the B sample. So the A and B samples of each collection are going to be sent to the same laboratory, and the responsible person or owner has the opportunity to have that B sample tested. They just have to pay for the analysis, and then they can get the full laboratory documentation package related to both samples analysis. We're going to be providing them an abbreviated documentation package from the laboratories at the time of notification. So they will already have some sense as to the analytical nature of the findings and the work that was done with respect to the sample. Once the B sample analysis is completed, and that will happen at the same laboratory that does the A sample, just with a different technician, then there will be a charge. That charge, what's referred to there in the graphic, ADRV, is anti-doping rule violation or medication control rule violation. I mentioned what was defined as a medication control rule violation in terms of sanctions, but it's actually a little bit broader than that. It includes violations involving secondary substances that are minor infractions as well. So like I said, those secondary substances are generally therapeutic. So that's covered within the purview of medication control. They'll have 10 days to respond to a charge, or at any time they can accept a sanction, and it becomes, that'll be announced and published on the website. The 10 days, they can request, they can challenge the violation before a steward if it's a minor infraction, or they can challenge it and request a hearing before an arbitrator if it's a major infraction. And so that's what that process is outlining there. The timeline for the minor infraction versus major infraction, this is outlined in the arbitration procedures, which will come out Monday, but essentially it is from start to finish. So from the time the request is made to challenge to the reasoned decision by the steward, and that's necessary because all of these cases are appealable to an administrative law judge. And so we need to have reasoning for an outcome so that it can be upheld on appeal. So the time from request to be heard by a steward to the time of the written reasoned decision by the steward is 4 weeks. The time from a request for a hearing to a reasoned decision by an arbitrator, which includes in between a hearing with evidence being presented and arguments made, that process is defined to take 8 weeks. Now, because we have to and want to comply with due process within this program, we cannot say absolutely 100% every case will take this long. We can't do that. If we did that, it would be, the rules will be thrown out. But what we've done is we've encouraged to the strongest degree we could reasonably do that these timelines will be adhered to. And so those are the timelines that are outlined for the cases. And then as you can see, any reasoned decision coming from a minor infraction or major infraction can be appealed to an administrative law judge. That process is outlined in the Act. And then even the administrative law judge's decision can be appealed to the commission. Again, that's a process that was outlined in the Act. And so there are additional potential bites at the apple, but if you all look in the protocol, we've also, some are from the Act and some are from the protocol. We've inserted some deadlines related to these appeals to try and make them as efficient as we can. And I already mentioned the public disclosure piece. As soon as the violation is found, it will be announced. I think it says may there, but that's not correct. It's actually shall. So I think that was a lot of information for you all. So I'll stop there and turn it back over to Ed or to whomever may have some questions.
let's, you need to raise your hand to be recognized for a question. And who wishes to go first?
And Ed, there are some questions in the chat box that I'm seeing now as well. I don't know if you want to.
Yeah, so people who put questions in the chat box should raise your hand. Let's go to Bob Lopez first from Washington.
Thank you. I'm surprised by this July 1st deadline. If I understand what you said, is that going back in time, you can't go past prior violations prior to July 1st of 2022. Is that correct?
That's my reading of the act, and Tom, feel free to chime in as well, but that's how I understand it.
So what if a state has a particular trainer who has had some problems and they're looking at serious time under our rules? Are we to allow that trainer another 2-year pass? Is that my understanding? We can't take any enforcement action then?
No, so the states would still be in control of everything that's happened before July 1st and could continue to proceed with your adjudication of those violations. And so there's just that line on July 1st related to, it's really related to how under the new rules, whether you can look back. It doesn't affect the state's ability to continue moving forward with any violations you have pending.
Yeah, Bob, our reading of the statute is that any conduct that took place prior to July 1, 22 is within the sole jurisdiction of the State Racing Commission, both in terms of disciplinary sanctions and I suppose also in terms of licensing decisions going forward.
So let me comment on, kind of take this to the next level. Let me just, before we get to that, I just quickly pulled up the act and I looked at the section dealing with the things being prospective. Basically what you've just announced is that everybody's regulatory record of violations for drug or horse doping prior to July 1st next year is going to be wiped clean, and you're starting with a zero-sum thing. So you're not going to take into account a person's history. This will be the happiest day for people who have multiple violations. Now, I got to tell you, this is the first time this issue has really kind of come up, so I'm kind of shocked by it. And in reading the statute, you also see where the baseline rules are to take into place the RCI multiple medication violation system, which implies something completely opposite in terms of the intention of Congress as to what you've just announced. So I would seriously ask you to go back and look at this. I mean, this is going to be some people's happiest days because their entire prior history is going to be wiped clean. I'm sorry. I'm just, this just hit me out of right field.
And Ed, I mean, that's when I mentioned, I mean, I'm on board with you in terms of if there's a way to do it, then somebody please let me know. Because
well, I mean, my experience, with all due respect to all the councils on the call, there are two types of councils. There's the councils who tell you what you can't do, and there's the councils where you tell you what you want it, basically how to make it work or how to make it. It seemed to me that the USADA, I'm assuming you're going to be the enforcement agency, should have the discretion to look back at somebody's regulatory history. I believe they do that. If a person's got a history of violating various state laws and they're brought up on federal charges, and it comes time to sentencing, I don't know the limits of the parameters, but my understanding is all of that is taken into consideration as well as the specifics in the crime. If somebody's been convicted in other states and they get convicted of something in one state or at the federal level, if they pose a danger to society, they're usually put behind bars. So I've said my piece, and I'll just let it go from there.
One thing on it, Ed, is I'm not being a lawyer, I'm not going to, I'll leave the interpretation of the act to the lawyers. But whilst, as it currently stands, from what I understand, we can't use the history as part of the sanctioning per se. We certainly will not be ignoring people's history when it comes to looking at who we go and test in, or on race day or out of competition. So as far as that goes, that historical information that is a matter of public record will certainly be used in assessing people's risk as far as use of either misuse of the therapeutics potentially, or use of more nefarious drugs. So don't think that the information is going to be ignored. It certainly will not be, and we will use what, to the best of the ability that is provided for in the act. We'll certainly be using that information, because I agree, we don't want it to be a free pass where people think they can use it as a way to continue to do the wrong thing.
Ed, if I may, I'm in no position to respond to your grievance, and I share your concerns. I'm not in a position, because I've not been privy to the input that the board has received from outside counsel. But I would encourage those, including yourself, who feel that that is either an incorrect reading of the law, or is a portion of the law that should be changed, if it is a correct reading, to submit those comments to FTC for their consideration.
And I have a couple other things I could want here. Ed, you're muted.
Actually, you should hear me now.
Yes.
Okay.
Before I get off, I just have a couple comments. I don't need any response. Earlier, Mr. Cook, you referred to aggravated circumstances. I would ask that the authority consider at least defining mitigating circumstances. Nothing is ever black and white. There's always shades of gray. Secondly, the language that you have proposed is, if you expect, it's difficult to follow, difficult to understand. And if you expect horsemen to comply with it, they should at least be able to understand it. You keep moving back and forth, referring to different sections. By the time you turn the page to find that section, you've probably forgotten what you were looking for. It's hard to do. And finally, it would be helpful if you would paginate the document. The first draft did have page numbers. The second one didn't. And yesterday going through it, I had to, they were all over the place and I could hardly put them back together. So that's all I have. Thank you.
Yeah,
Let's
so
go to Duncan Patterson.
Thank you, Ed. My understanding of this act and HISA was to fix things that were broken. A lot of research, time, and effort had gone into structuring our levels of the medications and the violations thereof, and the penalties associated with those various different levels. Why change something that's not broken?
Duncan,
Jay.
I'll respond to that. I mean, that, I heard Alan Foreman's speech this morning as well.
No, I didn't. I did not hear Alan.
We haven't heard. I don't think most of us did.
Well, I think the general question is, the problem was not with the rules themselves. It was a lack of uniform adoption and uniform application of the sanctions. And the question you're raising is a policy question, which will be decided by the board.
But Tom, to respond to that, the purpose of the HISA is to make sure that the rules are consistent throughout all jurisdictions. You could
Yes.
have just taken the existing ARCI rules and made them consistent with a requirement of all jurisdictions. I said,
So-
why restructure this? I mean, you made it so confusing and difficult, as Bob has said, for people to understand.
I would ask Jim Gates, who staffed for the anti-doping committee, to kind of explain what the thinking of the committee was in basically doing a complete rewrite.
Yeah, thanks, Ed. Well, I mean, we've worked closely with Usada, who Usada was the one who they drafted the documents. Our committee of 7 has worked closely with them and has made some changes with Usada to get the documents to where they are, and they are still a work in process. We're doing with USADA, trying to make those as good as possible and taking into account the input that we've gotten. We've gone out to almost 30 different stakeholders in the industry, and we continue to receive feedback and are making those changes. But we have just agreed with USADA that in some cases that this is what the act calls for, and in other cases that this is the best way to handle these things.
Doug Moore.
Just as a little bit of follow-up to what Duncan was talking about, is just moving the ARCI rules. After our meeting on the safety issues, I had a long discussion with our legal counsel. She sees a lot of problems with us implementing these rules, having 2 sets of rules, the USADA or HISA rules and our rules. She indicated it would have been much simpler if HISA would have come in and said, adopt the model rules. Each state would have to adopt them at their own level. And then it gives us the enforcement ability that we may not have. She has a lot of concerns about us enforcing HISA rules as a state agency. So I agree with Duncan. The simple fix would have been to say, adopt the model rules or you don't export your signal. And you adopt it state by state, and we're on, everybody's doing the same thing.
Well, Doug, the statute that was adopted puts the rulemaking and the enforcement responsibility, takes it out of the hands of the state and puts it in the hands of this new federal authority and their enforcement agency. And to the extent that, so, I mean, you're not going to be asked to enforce the drug rules. You're kind of out of that picture.
Well, sorry, and she also we're giving the license as a state agency. Does this federal authority come in and take action on our state licenses?
I don't think they have that authority.
So if that's a question, the covered persons are those who are licensed by state racing commissions. So the licensing decisions remain with state racing commissions.
Can I ask a question? Since a lot of state racing commissions, covered persons also includes breeders. A lot of state racing commissions do not license breeders. How do you reconcile that?
Well, I think,
I mean, we don't need to answer that now, but I would just say that's an issue that's going to come up, and it will probably come up when the assessment of fees by HISA comes down. Lou Trombetta from Florida's got a question.
Ed, before we go, I do want to answer your question. Yeah, my reading of the definition of covered person is that it covers people who are licensed by state racing commissions, and if state racing commissions include breeders in that licensing, then they're a covered person. It's a question of how the syntax goes in the definition, and you can read it 2 different ways. I appreciate that.
Yeah. So in other words, if it's possible that when the assessments come down from HISA, if the state does not license breeders, then the breeders get a free pass on having to be responsible financially for any fees imposed.
If it's read
under that interpretation. Yeah.
Yeah.
Okay, Lou, you had your hand up next.
Hey, thanks, Ed, and thanks for everybody on the phone. More of a recommendation than a question. Just I spent a lot of time going through the regs that are posted on HISA's website, and I guess I'll compliment that it's kind of easy to follow. I like that there's a lot of the way the comment section is set up. If people haven't looked at it, that's going to be a good way to submit comments if you want to. But my issue is that for states like mine that wants to submit some comments, I mean, it's a little worrying that I just heard the December 2nd. It sounds like there's a meeting that might be, I know you suggested we get comments in before December 2nd. It seems like it's a living document. Is there going to be any period where either the PDF will correctly reflect everything that's on the website, or where the website itself will kind of stop changing, or all the other documents that are not there will be incorporated so that we have time before December 2nd to kind of go through everything and make comments where we'd like?
Jim, you want to take that?
So as Jeff mentioned earlier, the other documents, the remaining documents that haven't been posted, so meaning everything other than the prohibited list and the protocol, should go up in the next few days, no later than Monday is our goal, Monday the 22nd. Those will remain up along with the prohibited list and the protocol and be available for public comment up until that date of the the December 2nd board meeting. I don't believe the plan is for, I mean, we will be working behind the scenes to take those comments and make changes, but I don't think new versions will be posted between then and that December 2nd date.
And then what gets submitted on December 6th will be frozen because it's in the FTC hands. But you could still comment to both us and through the FTC notice and comment period, correct?
Joe, yeah, you can put, we know Tom, that's a given. Public comment to the FCC. Joe Lucas from Oklahoma.
Yeah, under your, and I'm basing this off of the version that was posted on 11/11. Is that still the current one? If it isn't, I'm wasting my time or your time asking these. Is that the version still out there that was posted, I presume? Or has there been a new one that I'm not aware of?
It is. It is.
Okay. Under in the definitions, under covered persons says all trainers, right? Am I correct still? Grooms says covered person. That I'm under definitions. And it go down later to 2.2. It says anti-doping ruling violations may only be committed by covered persons, which is trainers and grooms. Versus 2.5a, it said it is a responsible party's duty to ensure no prohibited substances enters their covered horses' bodies and the method used. And definitions of a responsible party, when you go to that, responsible party shall be the owner post-claim race. So only only claim, I mean, I'm not following how that gets there. And I'm not, if you don't know, you don't know, but I'm just pointing these things out. That's what it.
No, I'm concerned that so just for everybody's reference, we had PDFs that had to be converted into this form on the website, on the HISA website. So based on what you said, Joe, I'm concerned that significant portions of the definitions are potentially not there, because the definitions that in the document were much more comprehensive than what you just described. And so
and listen, this may be, I've had this before, and that's what I wanted to make. That's why I was prefacing this with what I'm looking at, because I can't believe other people have not said something if that's right. But I think maybe it is that I do have an Apple product that I view this with. And when I get it, it's not on like a Mac computer or whatever. And sometimes what I get sent to me by my racing commission, they have to send it in another form, or I'm looking at some version that is not current.
Well, Joe, just so I'm gonna recommend that PDFs be made available on the site as well, just so there's a way to easily view them. But ultimately, that's Jim and Tom's call. But I think that would be helpful for folks trying to see paginated versions of how everything flows together. But
Okay.
to try to just give you a brief
Well, I mean,
overview.
it's okay. If I'm looking at a bad version, I understand. You put up something else and I'll go to it and review it
Yeah.
too.
Hey, Jeff Cook, I'm looking at the website right now, and it's covered persons is defined as all trainers, owners, breeders, jockeys, racetracks, veterinarians, and persons licensed by a state racing commission, et cetera. It goes on, so it does include more than.
Well, I know there's potentially issues with Apple users on the site. So I think, Jim, the PDF, if there's a PDF available, it could solve that issue, since that could just be easily read by multiple platforms, iPad, mobile devices, et cetera, et cetera.
Okay, I won't waste your time anymore. If I'm looking at a bad draft, Ed, I guess cancel everything out of those 6 pages I sent you.
I've actually just downloaded the regs on the HISA website, and when you look at covered person, it just says all trainers, full stop. So Ed, what we might try and do is get can we get a PDF to Ed of those documents so he can circulate?
Well, what we've done, I mean, we circulated the PDFs that I received from Tom.
Okay.
And those are the ones that we put in the emails that we sent out, and you could download them from those emails. The website, we didn't go to the website, and we had a concern with the track safety rules that they may have changed from the point when I circulated the documents I received from Tom to what was on the website. I just think people have overthought and made the commenting process maybe a little bit too technologically complicated, rather than, given the time constraints, the easiest thing would be to post the PDFs, then ask people to submit comments in writing, and you can always cut and paste them when you do your required reports for your submissions. But somebody kind of overthought that.
I'm getting texts from people, I guess, who are hearing me say this, but they're texting me on my phone. It's a vet our state vet said the HISA website downloaded PDF does not have the correct language.
Yeah, that's what we just saw. That's what we're.
But that's your website. You're being HISA.
Yes,
I mean, that's what we use. That's what we use to review. That's all
that's what Tessa just mentioned. I think that what Ed is saying, if I understand it correctly, is that what he sent was one that was a direct PDF from us. So it likely has the correct definitions for some reason that we're going to have to look into. If you look at the HISA website, it has the correct definitions, but if you download the PDF, it does not. So we're having to check on that.
Okay.
Okay, George Guster, Pennsylvania.
Morning, thank you. Just a couple of questions. Who will be drawing the actual samples for collections? Who's responsible for that?
So the collections are ultimately the responsibility of the agency, but the goal is to work with each of you all and the state racing commissions to reach an agreement in terms of how best to use the resources you all have in that area to make that as efficient as possible.
So in essence, then, for instance, Pennsylvania will decide if we test all winning horses, a couple of specials, and what have you. Who will decide which ones?
Sorry, I misunderstood the initial question. I was speaking just in terms of doing the collections, and in terms of who's deciding which horses will be tested. That would be done by the agency. By agency, I'm referring to the enforcement agency, whatever entity that.
By USADA if it's USADA,
USADA
or somebody else if it's not USADA.
Correct.
So
But
my
it
point.
will not be, it will not be the Pennsylvania Racing Commission or the stewards.
Okay, so my point then in terms of, we have no idea how many samples ultimately then will be tested by USADA or whatever agency is doing it. So we have no idea about that.
Not today, no.
Okay. Another question. When you talk about an arbitrator, at least under my analysis, an arbitrator has always been a non-judicial system. By having an arbitrator involved in the preliminary, what should be a preliminary hearing, how is that working? How is that going to work with an arbitrator who's generally doing a settlement between two parties, two opposing and competing parties?
So
How does that work?
Sure. Yeah, so dispute resolution takes many different forms. The one that you described in terms of reaching a settlement, that would be a mediator. And so mediation is a specific discipline within dispute resolution. Arbitration is distinct from mediation, and that arbitration is more analogous to a judge hearing evidence and resolving a dispute between parties with a written, in this case, with a reasoned award or reasoned decision. So that's the distinction, and arbitrations are prevalent throughout the United States and the world in terms of resolving disputes in that way.
What level of administrative process will be used for these arbitrators, i.e., what type of evidence will actually be admissible or being admitted at this proceeding in front of an arbitrator?
So it's a very, there's a lot of latitude in terms of the type of evidence that is permitted in arbitration. And it's essentially the arbitrator determines what he or she feels is relevant and helpful. And then the arbitrator makes the decision based on all the evidence presented. So for major infractions, there would be a hearing in which witnesses are called, and could be expert witnesses, could be fact witnesses, could have expert reports submitted, all the things that you would normally see in a trial that can happen and it is expected to happen more or less within the scope of the arbitration.
And is this arbitration then a final adjudication from which there can be an appeal, correct?
Correct. An appeal to, so the appeal process is set forth very specifically in the act. So the appeal is initially to an administrative law judge and then to the Federal Trade Commission.
What is unclear in the act, and perhaps I've missed it, is an appeal to the administrative law judge a hearing de novo, or is it an appeal on the four corners of the record below?
That's a good question. I think there's some ambiguity in the act.
Yeah, I thought so.
The standard set forth in the act is a bit of a hybrid standard, and I don't have the wording in front of me, so forgive me for not quoting it precisely, but it's essentially a mixture of de novo and discretion, or for abuse of discretion as well. So it's a bit of a hybrid review. My reading of it was that it could be limited to the record in the first instance, and I think that's where the draft protocol goes with it. But that is subject to FTC review and discussions with the FTC on how they want to see that process set forth, because ultimately they're the ones who are in charge of that administrative law judge process.
And actually, that's a great follow-up, because then, so ultimately the administrative law judge, whether it's a hearing de novo or an appeal, now that matter then can be appealed to the FTC. Is that a hearing de novo, or is that on the record? Do we know?
So that is specified in the act. So 2 points on this. So for the FTC appeal, it's not, sorry, let me phrase it in the positive. It is discretionary. So the commission doesn't have to take those appeals. There is also a provision in the act that says that they can hear additional evidence, I think upon motion or something.
Yes.
And I do believe it is de novo at that level.
Okay, thank you.
Dr. McNabb. You have to unmute yourself. There we go.
Yes, sir. Thank you, Ed. As you say, the stewards are not going to be making the decision as to which horses to test, but instead that's going to be the agency. So is drug testing going to be unlinked from post-race, and that you all, based on your intel analysis and whatever the gonculator puts out, we're going to go see horse A who belongs to trainer B, and that's going to be a daytime thing? I mean, are you unlinking the post-race testing as the races are going on if you are taking away the stewards being the ones to decide? Because there's a lot of things that you see as races unfold that drive your decision. Horses that you scratch at the gate because they're refusing to go or they're too wired up. So if you say the agency is going to be making the call and not the stewards, are you unlinking it in that time frame? And then the regulatory vets are just there to scratch horses and deal with breakdowns.
So the time frame is not being unlinked to post-race testing. There will still be post-race testing, and there will be discretion to yet to be determined degrees, but there will be some manner of discretion for testing to be assigned, additional testing be assigned at the time of a race based on the circumstances that are present. So all of that is still going to take place and be factored into testing decisions. I think what's changing is who's making those testing decisions.
Just to add into that, like you say, there's a lot of things that go on in the race that will be applicable, like, beating favorites or, overperformers, underperformers, stuff like that. And I think some of those specifics of how the selections are done, I think there's a lot of valuable expertise in people who are there on the day, stewards reading the races and things. So those discussions and how we specifically address the selection of horses for post-race testing, which is definitely not being unlinked. It's a really important component of the testing program, obviously the race day and the post-race testing. So the specifics of that will probably be worked through on a state-by-state race basis as we discuss things like, are states going to work with us to do the collections, or are we going to have to send people in to do the collections? So I think some of that will be a little bit specific, and some of the stuff will iron out in relation to the operational elements of the program.
It's not a small staffing consideration to put that whole thing together. So if we're undoing that system, then it's now's the time to think about it. Thank you.
Anybody else wish to be recognized? Raise your hand. The question that I've started to get asked is, should a state provide a service for HISA? There is an increasing sentiment that they're going to wish to be paid for providing those services to defray the investment of state tax dollars. Is that being where does that stand with regard to HISA's analysis of potential costs and so forth? I've had numerous states come back and say, if we do this, then the state is going to, and that's envisioned by the statute, that is HISA looking at a grant program or a kind of a bill where the state would bill for the involvement of their personnel that they're paying for this?
Ed,
and don't shoot the messenger. I'm getting asked this question.
No.
I don't know the answer.
This is being worked on as part of the cost apportionment formula, but I think you referred to the possibility of an agreement between HISA and the states. There may also be agreements between Usada and the states, which may be more relevant to this discussion in the sense that for services provided by a state, whether it be collection, sampling, and things of that sort, there would be a formula for a credit or a set off against the state's proportionate share of the cost of the program. And exactly how that works is under discussion right now.
Yeah, and I would just advise you to separate out, because when you say the state's proportionate share, separate out what the state government's share would be. Not a share that you would assess on racing interests that you have the ability to assess costs on in that state. The state government is obviously a separate entity, and I advise you to split those apart when you're figuring that out. What's happening is, as people in state governments are looking at the details of this, they're looking at an entity that was given the ability to raise its own money by federal statute, and they're looking. I mean, these are people who state racing commissions have had to struggle with to get their budgets approved in the past. These people are looking at an opportunity to maybe lessen the amount of money that the states pay for this, because HISA has got the ability to raise that money and potentially reimburse the state. And that will be a rubber meets the road conversation that whomever is dealing on behalf of HISA and ultimately Usada with the individual states, that's going to come up. So if a state is spending, and I hate to say it, if a state is currently spending, $1 million a year for its sample collection and lab, the question that's going to be asked is there a cost sharing grant that's coming from HISA to help defray that? And then that would become an incentive for the state to continue collecting samples and running the program the way it's envisioned, at least on the anti-doping side. We had a question, and I think it was answered in one of the graphics, but one of the questions that I got from Joe Lucas, and I think, Joe, 4 o'clock in the morning, you sent it to me, or whatever time it was. And it had to do with the prohibited list. Does it apply in competition or at all times? And I'll let Dr. Muir maybe handle that one. I kind of know the answer, but I'll let Dr. Muir address it.
Thanks, Ed. I'm not, I guess, hopefully I've interpreted the question correctly, but if not, then just shout and I can provide some more clarity. So the first part of the list is the things that are prohibited at all times. So that would be on race day and out of competition. And that's things like the anabolic steroids, other anabolic agents, things like that. And then the component with the S7, which is, and you may recognize that language is from the IFHA's document, which is that, essentially all substances that can have an effect are prohibited on race day. So that part of the list, so the prohibited on race day component, those are, the potential therapeutic medications that would be given to the horses when they're either resting or in training, but they're prohibited on race day only. Of course, there is also the need to comply with the state and federal legislation in relation to the administration and the prescription of veterinary medicines. But so the list is essentially separated into those two components. Did that answer that question, or?
Well, I mean, the existing rules in the U.S., with the exception of Lasix, prohibit anything that can affect performance from being in the horse on race day. So that's not a change. It's just packaged differently. And there's a lot that's in these rules that is very similar to what's pretty much being done. When I look at the total prohibition, and I'll let others ask these questions if you want, but when you look at the total prohibition, the primary substances are prohibited at all times, but I'm sure that there are some potential therapeutic substances that might be given for a particular treatment to treat a horse that has a medical need. There does not appear to be any mechanism, as there is in human sport, to provide a therapeutic use exemption to do a workaround of that. So and I'm looking at things like, you've got clenbuterol is probably the one, but I'm not a veterinarian. I'm certainly not there's people on this call far smarter than I to basically address that. But as it's presently written, you're pretty much denied. I'm assuming there's other medications that in the practice of veterinary medicine, somebody may make a determination that that horse has a medical need and they may need to treat that horse. But are you not putting that horse and whoever treated that horse potentially at risk because you don't have a therapeutic use exemption program?
Like Ed, you just posted the question I posed about clenbuterol. FDA approved, but it's a prohibited substance. And does that mean it's prohibited at all times?
Currently, that's one of the ones that we're actually looking at as far as, sort of looking at that rule and seeing whether there should be an exemption. So one of the things you'll see, for example, in that part of the list, Ed, is there are various exemptions under each of the sections for things. So for example, like plasma expanders or the need to do a blood transfusion for life-saving purposes. So there are exemptions within that are available for those things that would have need for use in those emergency life-saving situations where there's potentially not something else to treat the horse. And the clenbuterol is one of the ones that's being discussed to see what exemption, if any, should be in there, obviously to allow it to be used in certain circumstances without the potential for it being abused for its anabolic effects.
So the system that's been relied upon in the states, and again, some of this is packaging and formatting. I mean, we've got a prohibited list in the RCI model rules. It's pretty much used in combination with the uniform classification, which basically takes certain medications and provides a recommended penalty, but classifies them on the degree to which they potentially could affect performance if they were found to be in a horse when it raced. And some of that takes into a place, a mitigating. I guess because the current system in the U.S. has been focused primarily on the competition and has not regulated the administration of legal approved medications that are given to horses by a medical professional, hopefully based upon a legitimate diagnosis. That's been a situation that we feel has been abused. So this is obviously going to tighten that up. But the question is, in tightening that up, are you hampering the ability of veterinarians to properly treat horses? And I'm not a veterinarian. There are people on this call who are far more knowledgeable than I am on this. And I just raised that question because what the exemption you basically made was for life-saving treatments.
Yeah, and I would encourage if there's specific things, certainly from the veterinarians. And I know I've spoken to both some of the practicing vets and also a number of the regulatory vets. So if anyone's got any specific things where they have feedback on that, then that obviously would be great. And I'm very happy to chat through any of those with the vets who think of things. As I say, I've spoken to a number already and had some discussions around certain things that are on there. So more than happy to go through some of that stuff.
And I just saw, Ed, if I could just
sure,
comment on something that was said in the comments about clenbuterol. There is an exception for trafficking in if you look at the definition of trafficking, which hopefully it's all there. But if you look at the definition of trafficking, there is an exemption for bona fide medical personnel who are handling prohibited substances for a genuine, the wording is a genuine and legal therapeutic purpose or other acceptable justification. So
where is that at, please?
That's the definition of trafficking.
Okay.
Anthony Salerno, Pennsylvania.
Yeah, thanks, Ed. I just wanted to follow up on something Dr. McNabb asked earlier on the testing. Currently in Pennsylvania, we test every winter. We do 4 or 8 specials a day, and it's also in our regs that every cleaned horse gets tested. And and maybe I'm misinterpreting the way I'm reading the draft, but I'm getting the impression that when USADA takes over, it'll be more targeted testing, based on horses' past performance or trainers, batting averages or whatever you want to call it. And I guess my question is, what happens we have it in our regs, we got to test every claimed horse. Come July 1st, when we no longer call who gets tested, how does that work? Does our reg, we can't enforce our own regs anymore at that point, basically? Or am I wrong thinking my train of thought as far as it being more, the testing when you guys take over is going to be more targeted? It just seems to me that's the way it's looking.
Yeah, so a couple of points there. So to clarify, the rules don't comment on the number or test plan that will be in existence under the program. That's something that's separate from the rules. The rules do, and if you see the testing and investigation standards, which again be out Monday, but those rules do comment on sort of that process, but don't comment on specifics. Those specifics in terms of numbers, claiming horses per race, that's all being discussed currently between HISA and USADA. The generally speaking, the idea is to increase out of competition testing, which I think is what you were referring to as target testing. Target testing is sort of a subset of out of competition testing, but that don't need to get into that right now. But generally speaking, out of competition testing will increase quite a bit nationally. That doesn't necessarily mean that race day testing is going to decrease, but I can't, of course, say that because every state does race day testing at different levels, and that hasn't entirely been settled between USADA and HISA at this point. So I'm sorry I can't go into many more details, but I think the idea is not to just decrease race day testing dramatically and increase out of competition testing. That's not the idea. The idea is to have both at a very good, productive, level that will deter and catch doping.
Okay. And then Chairman Lopez had asked a question earlier about, and I know you guys said you can't go back to a person's record as of July 1st, but we, as a commission, we ask our stewards and judges to use mitigating and aggravating circumstances when people get positive tests. And usually a lot of that is based on their past record. So if we have someone who's had 3 or 4 positives in the last year, and he gets a positive after July 1st, as far as you guys are concerned, that's his first positive. He didn't have those other things. You're not going back looking at that. But as a commission, can we take additional action against that licensee, aside from whatever penalty you guys are going to give them? Could we, whether it's a revocation of a license, if it's a serious enough offense, or are we no longer allowed to even, have a say in what his previous record was when it comes to taking action against a licensee based on his previous record? You know what I'm trying to say?
Yeah, no, I understand the question clearly. And so it will certainly be within the commission's purview to effectuate the sanction that is imposed under these rules. And whether that means revocation of license or other things, that is up to the commission. This issue comes up a lot in the human world that have applied these sets of rules, and on the human side, there was a really like a seminal case on this very topic, analogous, where a sport body wanted to impose an additional sanction on an athlete that was over and beyond what the rules required and were imposed under the rules. And ultimately, a court a sport court, I'll call it, decided that they couldn't do that. Of course, in this context, we have a different regulatory scheme. And so I don't know. I haven't done research on that specific issue and couldn't really opine on exactly what the percentage of likelihood that would be to survive challenge. I think the intent is for these sanctions to be uniform and to be the final sort of resolution of these cases, not for states to take them and kind of add penalties to them. That I think that's the intent, but whether or not under certain circumstances related to licenses and prior violations, you could do that. I honestly don't.
Yeah.
I don't know.
Tony,
No,
Tony, I was going to say in my former life as an executive director, I would be working with my council to see if there were some conditions of licensing or suitability for licensing decisions or some other tools that the state racing commissions had, either to place higher scrutiny on particular people or to place conditions on their licensure, which is within your authority.
yeah, and that was, I was going to follow up with, we currently do have conditional licenses that we put people on who have had violations. And, my first thought would be if one of those persons gets a positive after July 1st and he's on a conditional license, and according to our regs, we would take, action against that conditional license, whether it's a stricter penalty or if it's serious enough, it could result in a revocation. But that was just because that's a lot of open issues. I think right now, between the thoroughbreds and standardbreds, we probably have over 100 people who are on conditional licenses. So, it's just a lot of open questions. I think everybody has, but just want to get it out there.
Let's go to Virginia Fields of Texas.
Thank you, Ed. A couple of questions and one comment real quickly. In Texas, albuterol is prohibited on the backside. It would be contraband in Texas. Under your 20.1 D2 exceptions, you're going to allow albuterol when prescribed by a veterinarian as a bronchial dilator in the appropriate dose. That may somewhat be of a conflict. Primarily, my comment goes back to the multiple violations, and this would be after the effective date and just how that implementation would work. Because if you look at your rule 1011C, that's headed as additional rules for certain potential multiple violations. And I'll kind of put it into a hypothetical. Say we've got trainer of the year, and he comes out and, unlike a human who can compete in just relatively limited circumstances, not multiple closely held competitions, you've got a trainer who can enter a horse and horses in multiple races. And trainer of the year comes in and enters several horses, let's say 5 horses over the period of a month. We test the winner of the first race that horse comes in, and he comes back for frog juice, dopamine, nomofensine. And then according to this rule, it says if the agency can establish that that the responsible party had received notice of the first violation. But a lot of times with the laboratories and the returns of those positive results, you get them rather all at once. Say he competed every week for a 4-week period, and then we get the positives back. You may not have time to get a notice out for the subsequent violations to be considered a second violation. The point of an administrative sanction is to deter future violations, to stop the really bad guys. And it looks like under this rule provision, if you don't provide notice of the first violation when it's received, any multiple violations received before notice are going to count as a first instance or a first violation. And that would be the sanction that would apply for multiple violations. And this is subsequent to the act. So when you don't necessarily test certain horses, you may be missing those violations. And then again, when you don't provide notice upon initially receiving a first violation, and that really bad guy is committing several violations in the course of a couple of 3 weeks before your full drug results come back, you may be missing the point of deterring future violations. There may be a slight loophole there, I guess is the comment.
Yeah, thanks for that. So, so I think two things. One, the turnaround time for labs, we're expecting it to be, well, Tessa could probably comment, but I think it's about 4 weeks. So hopefully there's not too much time there between the sample collection and the notice, because the notice would go out very, very quickly after those results are received. But I think the loophole is closed, or we tried to close that loophole through aggravating circumstances. One of the provisions of aggravating circumstances is if there are multiple violations. So your hypothetical is correct, or how you described it in terms of those violations being being considered a single violation for purposes of the multiple violation multipliers and being brought in one case. However, we could allege aggravating circumstances and double the penalty to 4 years if it's primary substance, or if they're medication control or medications, secondary substances, then it could go from 30 days to 2 years if there are aggravating circumstances present. So I think that loophole is sufficiently closed by aggravating circumstances, but you're right, there is a window that multiple violations would be not subject to that multiple violation multiplier.
Elizabeth Stinson, you were next. Florida.
Thank you. I was looking at the HISA statutes and the prospective application part. And I understand that the authority and commission may not investigate, prosecute, adjudicate, or penalize conduct in violation of the horse racing, anti-doping, and medication control program. And that, in states, it's the same thing. You obviously can't do retroactive application of law, but in every state, well, certainly in Florida, you have the ability to look at the record and use that to penalize people and have that be an aggravating circumstance. And I was also curious in terms of how it was going to work in that overlapping period where states are wrapping up their administration of their programs when HISA had taken over.
Tessa, Jim. Jeff. Somebody.
Well, just to the first point, I mean, it's again, I'm on board with using prior cases if we can. And so if there's some way to do that, then I'm all for it. I'm not. It just wasn't my reading of it when I read it. But as Tom said before, like if you have a different take on it and can provide that to us in the comments, like we'll be more than happy to look at that and see if we can get some legal arguments to justify that.
Thank you.
Elizabeth, I was just going to say, if you put comments to that effect, either to us or into the FTC, the authority has to respond to those comments. And there may be a situation where the authority would respond and say, we agree with the comment, but our reading of the law is such that we don't believe we have that authority. But if we do, FTC, we would accept that authority.
Great, thank you.
Mm-hmm.
Duncan Patterson.
My question is involving split samples. You state that you're going to send the split sample back to the same lab. What was the thinking behind that? It just seemed logically thinking lab is going to confirm their own original test, regardless of whether you have a different technician or not. So to me, that's kind of counterintuitive.
We haven't had any issues with that. Like I said, there's the documentation is going to be thorough and provided. If there are any issues with the analysis, that can be raised. But we've been doing that for over a decade and never had a single issue with that. And it's
But you're doing it
much more efficient.
with humans. We're talking about horses.
Well, it's your analysis or blood analysis. It's all analysis of samples.
Joe Lucas. Joe, you got to unmute. Nobody can hear you.
Sorry about that. You may have answered this previously, but I didn't hear if you did. Who is going to do the actual accreditation of these labs? Who will do that?
You want me to take that one?
Someone.
So the Act has the enforcement agency doing the Lab Accreditation Program. So one of the things we're working with the labs, and I think we have talked about on some of the State Racing Commission calls, probably not all of them. So I doubt you missed it. But basically, we'll look to work through that accreditation program with them, and there will be sort of various steps put in place in relation to that accreditation program.
Well, who will do that? USADA is going to accredit them?
Correct. As it's currently worded in the Act.
Okay. I don't know whether you call them screening levels or whatever, with all these labs, they're either going to have to all be the same or they're going to have to be screening levels established. And if that's the case, if that is what happens, who is determining the screening levels?
So that's one of the things. So you're correct. The Act, again, it talks about using the IFHA's screening limits approach as far as the determination of those. Again, it's something that's going to be we're working through with the labs and with the committee at the moment as to how those are determined and agreed upon. But there will be screening limits in place for substances.
And my question is, who will be the person determining that, or not person, but what entity will be determining that? Do you know yet? Or
I mean, ultimately, I guess it comes under the accreditation program. But as I say, the specifics of how those are agreed is something that we are talking through with the committee. And obviously, Scott Stanley is on that. A number of them are published by the IFHA, so they're already determined. So yeah, that's something that's being worked through at the moment.
Will the commissions be made privy to those, or is that just between you and the lab?
The specifics of it, I mean, I guess I'm not entirely sure what that will look like, because it's not been agreed. I mean, we don't even have the contract with the authority to determine those things, but we'll certainly be looking at the relevant expertise from laboratory and other expertise to make sure that we get those suitably in place.
Okay. A question on your notices that you have on written, your written notice to the responsible persons, the owner, whatever. What are you defining as written notice? Have you discussed that or plan to put that in there? Because we have had issues on that in the past in court on what constitutes written notice.
So email would be considered written notice, but yeah, if there are some issues with email being considered written notice, then certainly we want to.
I think you need to just cover yourself. I mean, I'm suggesting you might want to look into that, because in courts, when they have been appealed, if it was in a timely manner or not, we've had issues on it. But The other, on my last thing that I'll take up any time with you on, or I hope, on passport findings. Who is it that reports that, and what standards are going to be applied in that and passport findings? Who's doing that?
So I think Tess and I can probably both handle this. I'll handle it from a rules standpoint. So in the protocol, I believe it's the first place passports are mentioned. There's a parenthetical that says when available. And so just from a rule standpoint, the reference to passports are placeholders at the moment. As that has not been developed, but I'll let Tessa add anything additional from a scientific perspective.
I think you probably covered it. The passport would be similar to the once it's available and developed. I know there are a number of labs that are doing work on it, such as Scott's lab up in Kentucky. Basically, those results will be reported and utilized similarly to the other analytical tests that are currently used. So I don't know, does that, between Jeff and I, did we answer that question? Or?
Well, will that be, HISA will be maintaining that data? Then that's who will be maintaining that passport information? It
would be kept by the enforcement agency rather than HISA directly, I think, because it's part of the information that will be potentially used to bring anti-doping rule violations. I would think probably more than medication violations, or used to inform target testing for our competition.
Okay, I'm sorry, it kind of cut out there. So you said by what? It's maintained by what agency? What?
Sorry, say that again.
It cut out. You said it'll be maintained by what agency? What did you say?
Enforcement agency. So Usada, whoever becomes the enforcement agency.
Oh, okay. All right. Thank you.
So I just make a comment to that. If it's not ready, I'm not sure why it needs to be in the proposed rules that go to the FTC. And also the question is, I think the only guy working in the US on that is Dr. Stanley. And I think the world of Dr. Stanley, but coming out of the committee, a requirement of this, it would not be a potential conflict of interest. So I just say that. Anyway, let's go to Steve May, who's had his hand up for a bit.
Thank you, Ed, and thank you for everybody that's participated in this. Just a couple of kind of comments on this, I guess. I know Mr. Cook addressed it, but I just want to reiterate my concern with this and not having a true split sample lab on this. I mean, I think that's a kind of foundation in drug testing in equine sport at this point, is that we're not only going to have one lab confirm or test for this, but if there's a question, we're going to send it to another lab just to make sure that first lab didn't make any errors. And I think that's been a bedrock in drug enforcement in the equine industry forever on this. And I think that's really a foundation and why we don't lose many of these cases. So I just at least want to make that as a concern. And I think that's a concern shared by others on this call. The fact that it's going to take 4 weeks to turn these around, and this was something that in the chat, my chief state veterinarian pointed out, as a safety protocol, when we're taking horses off a veterinarian's list, we will do drug tests on those horses to make sure that they don't have any kind of pain relieving substance in their system to mask any kind of pain. And knowing that that's going to be delayed, up to 4 weeks to get a test back, that will cause a lot of problems with a lot of trainers on that. So, if there's some way we can potentially address that as well, I think that's going to be pretty important on this. So, I think that's all I have right now. So I'll turn it back to you guys. Thank you.
I have a question from Dr. Hugda, who's participating by car. Where do androgynous substances like testosterone fit in? Do they have a screening limit or anticipated to have a screening limit?
Testosterone will have a threshold in fillies, mares, and geldings in accordance with the currently published thresholds from the IFHA.
Anybody else wish to be recognized? Ken Lowe, unmute your mic. Ken from West Virginia, Commissioner Lowe. We can't hear you, Ken. You got on mute. There you
How's
go.
that, sir? How's that?
That's better, much better.
Thank you. I didn't know I was unmuted. I would have been sneezing all this time. In regard to the split sample, and I listened to Jeff Cook very clearly, I can't imagine having the same lab do the same test again. That'd be like me going to a doctor to get a second opinion from the same doctor, wouldn't it? He said it's been done for decades on humans. I would have to ask Jeff, has there ever been a time when the same lab did the same split sample and it came back different? I'd like to have an answer for that one. Jeff?
Yes, B samples have not confirmed. It happens very rarely, but occasionally they do not confirm.
So 1 out of 100, 1 out of 1,000,000, 1 out of 10. Give me an answer, Jeff. I got to pin you down on this. This is important to horse. It's important to the integrity of the game. Please don't have the same test by the same people. I don't want the same results from the same doctor.
Yeah, I don't have statistics, but we're extremely confident in that process.
That's unacceptable to me. My opinion. Thank you.
Anybody else?
Ed, I'd sent you a text there. I just have to go back on one point that was made that I believe you said that the test results are going to take 4 weeks to turn around. Is that correct?
So I didn't say that. Somebody from
No, I'm asking, is that
yeah.
what, I've asked that in a text and other people have texted me back and said, yes, it was 4 weeks. Is that,
Yeah,
is that
I don't know.
exact
I'm not quite
estimate?
sure. I'm not quite sure who said
I think
that.
that I said that.
Yeah.
I said that because, but I'm not. That's in the laboratory. It's either in the laboratory standards or that haven't come out yet. I'm not. Tessa may have more information, but it's going to be a lot of the same laboratories. So that there will be a different menu likely for the things they're testing, but it'll be the same people.
So will
that you're probably dealing with.
Will the horsemen's purses be on hold until you let the commissions know to release the purses? They're going to be on hold for a month.
That'll be up to the commissions on how they want to handle that.
Well, I mean, we don't have any money other than what's there. I mean, if we're not going to eat it. So, I mean, I guess that's the answer. That's a rhetorical question. I mean, we don't have the money to do it, but you're expecting horsemen to be on hold for their purses for 4 weeks, up to 4 weeks or whatever it takes. And that race will be on hold, the purse money of that.
Or the price, or the purse money could be returned.
I think it's,
be returned.
I don't think it's 4 weeks. I think it's 14 days. And that also, again, that's something that's being discussed with the committee as far as what these standards look like. They will also be coming out next week, so people can have a look at that. There's also the option to expedite test results. So I think there was reference earlier to horses being worked off the vets list and things like that. So of course, some of those scenarios that have been referenced, the turnaround times would be amended in order to fulfill the requirements. So
Tessa or Jeff, I have a question. Is USADA going to have contracts with test labs?
Somebody's going to have to.
Yeah, that hasn't been determined yet, Tom, because I think that has to do with the HISA's financial arrangements with the states as well. So I don't think it's been determined.
Okay.
Any other questions? I have one last question or comment, and it has to do with the confidentiality requirement that you're going to require of a state commission. On the as I read the draft rules, the enforcement agency will notify the covered person, and that of a violation. and the violation really doesn't become public until it's final. But as I read it, when you notify the person of the existence of a violation, it's totally within the discretion of the enforcement agency and the person receiving that notice whether or not that is made public. That's not an automatic made public instance. Under the current system of jurisprudence in the US, that's reflected also in how state racing commissions, when a steward issues a ruling of a violation of a drug case, the existence of that ruling and the contents of that ruling are public. Just as unless it's a sealed indictment from a grand jury, but when somebody's, so I guess the question here is that's a lack of transparency in the process, and I'm not sure that requiring a state racing commission to not make the public that they may not be able to agree to that. So the other concern is it does, and I'm not this, don't interpret this the wrong way, but everybody's trying to keep honest people honest. And to the extent that somebody could get notified of a violation and that violation, nobody else knows about that violation could disappear, and sometimes appropriately, but possibly inappropriately. And there are, in state agencies, there are people who independently investigate those things and come in and audit, and provide some degree of oversight. So I would urge that lack of, I'm not sure the reason why that would not be something, when the minute you've given somebody formal written notice that they have a violation. I know that triggers a discussion upon what an appropriate penalty would be. And then if there's disagreement at that point, I guess you can levy the penalty, and then they have the ability to request the adjudication through an arbitration that you've outlined in the proposal. But I'm just a little troubled by the fact that the initial notification is not something that is done in the open.
Yeah, it's a good discussion to have, and it's the one that we've had many times over many years in terms of finding the balance between transparency and not doing more harm than is necessary. And so, one, the authority is going to be getting these notifications as well. So it's not going to be, USADA and the covered person figuring something out in a closet or something. Two, commissions can get notifications as well, just as long as they agree to abide by the provisions of the protocol in terms of confidentiality. So again, not trying to hide anything at all. The reason why I mentioned that this discussion has been ongoing for a long time is that on the human side, just for example, a recent example, when USADA began running the UFC's anti-doping program, the initial rule was as you described. It was to announce every positive at the time of the positive. Now, several years on, that rule has changed.
That's a different issue. Because you can announce a positive. A positive is what then you commences your investigation as to whether it was potentially environmental or something else, or is it just the lab finding that you're notifying them of? For instance, if a steward is told that there's a positive in a particular horse, that just starts a process where they try to understand, was there, and somebody gets called in and they have a explanation, and that starts an investigation. And then the results of that investigation are then reported back to the steward, and then the steward decides whether there's a rule violation or not. That's when the ruling is made. It's not just based on the lab finding.
Oh, I see. I think I misunderstood the question. I thought the question was, why wouldn't you announce it at the time of notification? Notification for positive tests are done, generally speaking, right after those adverse findings are provided to the agency, and then the investigation, happens simultaneously. And so if you're saying, if the question was, why don't you announce it once a finding has been made of a violation? Well, then that is what the rules say. The rules do say that once a violation is found, an announcement is made, whether that be by a steward, whether it be by resolution between the parties or an arbitrator.
Yeah, because the way I read that, it just maybe needed some greater clarification there. Anybody have any other questions, comments, speeches, jokes, anything? Well, thank you. I want to thank HISA and Usada for taking the time today, and everybody else on the call. I would encourage people to continue to digest this, and I know Usada and HISA are trying to get it right and get it a workable transition. So to the extent you can provide detailed suggestions or reactions or comments, I think you should definitely make your contribution to the public record. We've been informed that the deadline is open until the HISA board meets, but I would encourage everybody to make whatever comments you choose to make prior to that, so that they can be assessed. I don't envy the job of the HISA board to try to figure some of this out, especially with regard to the cost. But with that, anybody else wish to say anything? Tom, Tessa, Jeff, Jim?
Oh, just good discussion. Thank you for your input. And I'd reiterate Ed's remarks to put any concerns, questions in writing. This has a long ways to go before it gets across the finish line, and it's going to be considered by a lot of different people. So,
but I will say this. I mean, the thing that hits me is I do think that HISA, whether it be the track safety side or to a certain extent the anti-doping side, I think you made your job harder on yourself by trying to totally recreate wheels rather than get baseline rules in effect, do a transition, get up and running, and then kind of tweak it as you go forward. I mean, the rules that ultimately are adopted for July 1st, the rule books, we all, and Tom, you know this better than anybody, and Jim, you were a regulator, I mean, these rule books are living documents. They evolve. And I know there's a strategic plan to do different phases over at least Hank's explained that to me from HISA, that it's not going to be perfect on day one. Nothing's perfect on day one, but the workability of this is definitely affected by the extent to which you undo things that are already in place and decide to redo them. So I just close with that comment, and that's the kind of thing that drives cost as well. So we weren't part of those discussions early on, but I did share those thoughts initially with Chairman Sheeler when I had a 4-hour meeting with him in July. So anyway, thank you all for being part of this, and onward.
thank you, Ed. Thanks, everyone.